It's yet another ridiculous complaint in yet another ridiculous anti-AI case. The Authors Guild sued OpenAI for, well, the usual crap. Do I really need to go into it? After almost 2 years, you'd think they'd actually get somewhere close to backing up something, anything that they've claimed. But as OpenAI put out in a recent motion to dismiss, they hilariously haven't. They filed, to the extent that plaintiffs purport to assert a claim for direct copyright infringement based on ChatGPT's outputs, the claim is defective several times over. The complaint fails to quote or attach even a single example of allegedly infringing output, depriving the court of the ability to apply the more discerning, ordinary observer test, or from conducting any analysis whatsoever. Compounding that issue, the complaint contains no facts demonstrating the substantial similarity of the allegedly infringing outputs and instead relies on threadbare allegations and legal conclusions. Indeed, plaintiffs' output allegations are so facially deficient that they fail to clear the low threshold for notice pleading. Damn, you'd think there'd be something. Quote, courts regularly dismiss claims where the works at issue were not attached to the complaint and where it was impossible to assess substantial similarity. Though plaintiffs address allegedly infringing outputs in 39 paragraphs, the complaint does not attach a single example, no allegedly infringing summaries, outlines, characters, or any other content. In fact, the complaint does not include a single quoted sentence or phrase from any ChatGPT output. Instead, plaintiffs' output allegations consist entirely of vague and conclusory descriptions of alleged outputs, preventing the court from properly assessing whether those outputs are in fact substantially similar to any protectable expression. Plaintiff's claim fails for this reason alone. One of the complaints was, quote, when prompted, ChatGPT generated an infringing, unauthorized, and detailed outline for the next purported installment of My Sister's Keeper and titled the infringing and unauthorized derivative as My Sister's Legacy using the same characters. Yes, not even a real book, an outline of a fictional sequel. OpenAI responded, but outlines of the next purported installment of a copyrighted work are not per se infringing derivative works. Rather, to be actionable, the alleged similarities must arise from protected aesthetic expressions original to the allegedly infringed work. Yet the complaint provides no facts about what protected expression the outlines copy. To the contrary, the only factual description the complaint provides regarding any outline is that it is detailed. The other two adjectives, alleging that the outline is infringing and unauthorized, are legal conclusions and should be disregarded. Use of a character is not inherently infringing. Indeed, copyright protection does not extend to generic and generalized character traits or to stock characters. Courts have deemed allegations far more robust than plaintiffs as nonetheless insufficient to plead substantial similarity. Plaintiffs cannot avoid their obligation to allege well-pleaded facts regarding how the works are substantially similar in protectable elements by merely alleging general infringement of the derivative right. Look, I'm not a lawyer, but even I know you actually have to provide examples of infringing output. They reference Judge Vince Chabria's dismissal of almost every count in Cadre v. Meta, and for much of the same reasons, quote, the court dismissed the class plaintiff's vicarious infringement claim against OpenAI, finding plaintiff's allegation that every output of the OpenAI language models is an infringing derivative work is insufficient. As the court observed, plaintiffs failed to explain what the outputs entail or allege that any particular output is substantially similar or similar at all to their books. That reasoning applies with equal force here. Plaintiff's output-based infringement claim should be dismissed. And since their other counts depend on that one, they'd all fall like dominoes. Sounds like a no-brainer to me, but this is the SDNY, so who knows? And we know that Judge Ona T. Wong is biased in favor of the big publishing cartels, like most of the SDNY, but would even she put up with having her court's time wasted for 2 years? I swear these anti-AI cases just need to die the death. But with Congress now poised to write bogus unconstitutional laws against it, based on the horrific lies Josh Hawley and others told in a recent Senate Judiciary Committee hearing, it seems like it'll get worse before it gets better. Even with arguments as stupid, vapid, and baseless as this.